Hello friends, welcome back. This is the last video of the Rajasthan Rent Control Act. In this video, we will finish with the act, and at the end of the video, we will do all the previous year MCQs. Chapter 5A provides for appointment of rent authority, tenancy agreement, and period of tenancy. Three things this chapter is providing. This chapter is added by 2017 amendment. Section 22A provides for appointment of rent authority. So it provides state government may appoint officers of RAS not below rank of subdivisional officer. So RAS Rajasthan Administrative Service and not below rank of SDO as the rent authority for jurisdictional area of every rent tribunal to perform functions and exercise powers under section 22B, 22D, 22E, 22G, 23 and 24. We'll see this section later on. So basically, every rent tribunal has a rent authority to perform some functions under these given sections. Now, appeal from order of rent authority would be preferred to rent tribunal within 60 days. So now we know that appeal from rent tribunal would go to RAT, rent appellate tribunal within 60 days, and appeal from rent authority would go to rent tribunal, that is within 60 days. So the time of appeal is same for both the cases. So now order cannot be questioned otherwise than the appeal to rent tribunal. Of course, it is clear that there is no other way to challenge the order. Next section 22B provides about the tenancy agreement. इसमें basically clause 1 provides that after 2017 amendment no agreement to let or to take any premises on rent be executed otherwise than written agreement. So all the rent agreement shall be executed by a written agreement, and particulars to be communicated to rent authority by landlord and tenant jointly as per form in schedule D. So, after what will happen after 2017 amendment, all the agreements relating to renting a premises would be in written form and communicated to the rent authority jointly by landlord and tenant as per Schedule D. Secondly, if it provides for the agreements which were executed before 2017. So it has two parts. First, A, which says that agar jo agreement is in writing, it has to be communicated as above. So there is no problem if the agreement is already in writing. It has to just to be communicated as per Schedule D. But if there is no agreement in writing and the tenancy is oral tenancy, in that case, both shall enter into a written agreement and agreement to be communicated as above. So procedure to be followed is same. If the agreement is not entered, they have to enter in written agreement and communicate the same to the rent authority as per schedule. Further, if landlord and tenant fails to present jointly, LNT stands for landlord and tenant. Jointly or reach an agreement, both shall file particulars of tenancy separately. So if they could not reach at the joint agreement, they should file separately the details. So there is no exemption from filing details. Details have to be filed. Clause 3 provides agreement entered after 2017 shall be executed before the commencement of tenancy. So after 2017, any agreement which are being entered between landlord and tenant, they have to be executed beforehand commencement of the tenancy. And in case the agreement falls under 22 clause B, that means after entered before the 2017 amendment, it has to be executed within 1 year of 2017 amendment. So they have given 1 year time to all the existing tenancies to comply with the section of provision of section 22B. Subclause 4 provides that rent authority shall enter such information in a register maintained as per Schedule D and provide registration number to the parties. So they have to maintain a register. in which they will enter all the detail which were given by landlord and tenant jointly or separately. So, clause 5, friends, there is some interpretational issue with this section. That's why I have reproduced it fully and not in condensed form as I have done with other sections. So, let's read and try to understand what it says. It says the information provided as per subsections 1 and 2. So it means the information as per the schedule D provided by landlord or tenant jointly, or in case not jointly, then separately, shall be taken as evidence of facts relating to tenancy. It is clear till this point, and matter connected therewith. It is also clear at this point. And in its absence, any statement in the agreement. So now let's see. I have to change the color of the pen. In its absence, any statement in the agreement inconsistent with the details. So, in absence of what? This is a little bit unclear to me. Uh, I'll try to see whether we can resolve the issue. Inconsistent with the detailed file as per Schedule D shall not be received as evidence of the facts before the rent tribunal or the appellate rent tribunal. Basically, anything which is in contradiction to scheduled details given under Schedule D would not be received and received as evidence. This is clear. But the word in its absence, agar jo they are saying in its absence, in absence of what, whether in absence of the information as provided under subsection 1 and 2, if that information is absent, then how can the authority would have information as per schedule D, because the information which they are recording as per schedule D is the same information which the landlord and tenant is giving. But to construe the provision harmoniously, I think the it can be interpreted as, I am just giving my point of view. Isko we can understand like that ki information they have to provide as per subsection 1, as per subsection 1 and 2 shall be taken as evidence of facts relating to tenancy and matters connected therewith. So till here there is no issue. जो भी वो information देंगे as per subsection 1 and subsection 2 shall be taken as evidence of fact relating to tenancy and matters connected therewith. It is clear. In its absence, any statement in the agreement. So इसके absence में I think अगर जो they have to maintain a copy of that statements as well, in case they lose the copy which they have provided to the rent authority as per schedule D. In case they do not have that copy, in that case any in its absence, so since they do not have that copy, in its absence any statement in the agreement inconsistent with the details filed as per schedule D. So agreement की copy तो they must have, in case they lose the copy of the details as per provided as per schedule D, but they must have the copy of the agreement. So agreement में anything which is inconsistent with the detail filed as per schedule D shall not be received as evidence of the facts before the rent tribunal. So it basically means, if we construe it harmoniously, कि जो भी डिटेल्स इन्होंने दी थी एट दैट टाइम, अगर जो उनकी कॉपी इनके पास नहीं है इधर लैंडलॉर्ड और टेनेंट के पास, तो एग्रीमेंट में जो भी कुछ है that would if it turns out to be contrary than the detail which are with the rent authority, in that case the detail with our that are with the rent authority would prevail over the agreement. Now, moving ahead, clause 6 provides that rent authority shall upload details of all the tenancies with registration number within 15 days of allotment of registration number. So basically, registration number 15 दिन के अंदर अंदर they have to provide. So 22 clause C provides for period of tenancy. अगर since this is inserted by amendment, so it provides, and if the tenancy is entered after 2017, it can be for a period as agreed between parties. So basically it does not provide any period of tenancy. It further provides tenant may approach landlord for extension of tenancy before expiry of period. So if tenants want to extend the tenancy, he has to approach the landlord before the expiry. If agreeable to, landlord may enter into new agreement on mutually agreed term. So if they agreed, they can enter into new tenancy on mutually agreed term. If expired tenancy, uh, if expired tenancy not renewed and premises were not vacated, so in this case the tenant is holding over, and the premises are not vacated, it would deemed to be month to month tenancy on the same terms as expired to maximum 6 months. Thereafter will expire unless renewed. So basically, this provision further provides that in case there is tenancy expires and the tenant did not vacate the premises, it would it would turn into month to month tenancy up to 6 months. After it would be expired, and unless renewed. And I do not know whether the tenant would lose the status of tenant or not, because as per definition, it says that any person who he resides even after the expiry of the agreement. So I do not think that the status of tenancy would be cease to exist in this case. Now, chapter 5b, it provides about revision of rent in certain circumstances, security depositing of rent in certain circumstances. So, 22d provides revision of rent in certain circumstances. It provides if landlord incurred expenses due to improvement, addition, structural alteration in the premises occupied by tenant, except necessary repairs. So, necessary repairs are accepted. Landlord may increase the rent as agreed between landlord and tenant prior to the commencement of work, to be effective from 1 month after the completion of work. So, it basically says that except for necessary repairs, because it is the duty of the landlord to do all the necessary repairs, and for that purpose he cannot in any case increase the rent of the premises. But if there are structural improvement which are for the benefit of the premises, in that case landlord may prior to the commencement of the work discuss between the tenant, and they themselves can discuss what would be the increased rent, and if they are agree to the improvement, the rent can accordingly be increased, and it would be effective after 1 month of the completion of work. So, in case of decrease, so first one was for the increase in the value of the premises. Second is in diminution. So, in case of diminution or deterioration, the tenant can claim reduction of rent. Landlord may restore the premises or housing services, or agreed for the reduction of rent. So, in case by any chance or by any act of the landlord, there is a deterioration in the property, the tenant can claim the reduction of rent. And if he does not, if the tenant does not, landlord does not want to reduce the rent, he may restore the premises, or otherwise he would have to agree for reduction of rent. So lastly, in case of conflict, in case of conflict, landlord or tenant may approach the rent authority, which shall try to resolve the conflict and come at amicable settlement. If no settlement is arrived, rent authority may pass appropriate orders on the basis of material brought before it on record by hearing both the parties. So, in case there is any issue with respect to the increase or decrease of rent, anyone may approach the rent authority, and they would pass the orders as per the facts of the case. Next section is 22E. It provides rent authority to fix revised rent in circumstances specified in 22D. Basically, it provides further detail. Says that rent authority on application of landlord or tenant shall fix or revise the rent and other charges payable, and also date from which revised rent would become payable. Section 22F provides for security deposit. So, unless otherwise agreed, landlord can take 1 month's rent as a security deposit. अगर जो they have contrary agreement, in that case landlord can take even the rent of 2 or 3 months as security. security, or otherwise he may agree that no security deposit would be taken by him. That it totally depends upon the agreement between the landlord and tenant. But if there is no agreement, in that case 1 month's security 1 month rent can be taken as security. A security deposit shall be returned to a tenant within 1 month after vacating premises, after deducting liability of the tenant, if any. In case this is very simple, when tenant vacates, the landlord has to see whether any damage has been caused by tenant. In the If any damage is caused, he may deduct the amount accordingly and return the security deposit after deducting if there is any damage within 1 month. So amount has to be returned within 1 month after vacating the premises. uh, Third, if there is bona fide doubt to whom rent is payable, sorry, this does not belong to section. If the rent is not so returned, the tenant may file application to rent authority for refund of security deposit. So rent authority would accordingly dispose the petition. 22G, it provides for depositing of rent with the rent authority in certain circumstances. There may be cases when landlord does not accept the rent from tenant. In that cases, the act has given option to the tenant to deposit the amount with the rent authority, and it would be deemed to it would be deemed a valid discharge towards the payment of rent. So, it provides if a landlord does not accept rent tendered or refuses to give receipt. So, even in case when he refuses to give receipt, the tenant may deposit the rent periodically in time to rent authority. Second, if bona fide doubt to whom rent is payable, the tenant may deposit rent with rent authority. Thirdly, on such deposit, rent authority shall investigate and pass the orders based on facts of the case, and deposited amount shall be accounted for and prescribed and kept in personal deposit account, and shall be operated to pay landlord and other lawful claimants. So, next, such deposit shall not operate as admission to correctness of rent, other facts stated by tenant. Basically, since he is not the landlord is not accepting, in that cases only to save the tenant from the ground of eviction on non-payment of rent, this provision is, I think, made. So so it has only that much purpose. So it cannot be taken operate as admission to the correctness of rent. That may be disputed by landlord later. Chapter 6 is about amenities. So, section 23 provides landlord not to discontinue or withhold amenities. So, all the Rent Act basically prohibits landlord from applying any coercive measures towards the tenant in order to evict him or to oppress him. So, this basically says that no landlord shall discontinue or withhold the amenities enjoyed by tenant in respect of the premises let out to him, except with the permission of rent authority. So rent authority may give permission, and which shall be granted, which shall be grant. Such permission shall be granted if rent authority is satisfied that is satisfied that the tenant has not paid charges in respect of amenities which he was liable to pay. So if the tenant is liable to pay if charges from some services which he is not paying, in that case the rent authority has to grant permission for withholding of amenities enjoyed by the landlord. Enjoyed by the tenant. Secondly, on application by either parties for withholding or restoration of amenities, rent authority shall issue notice to opposite party and pass orders as it deems fit after hearing the parties. Proceeding are to be conducted in summary manner, as in whole of the act. The all the proceedings are conducted in summary manner. Application has to be disposed within 60 days. So this is the shortest time for an application to be disposed, I think, in this act. So application has to be disposed within 60 days from presentation of the petition. Rent authority may pass appropriate interim order during the pendency of inquiry under this section. So although the application has to be disposed within 60 days, even then the rent authority has given power to pass interim orders during the pendency of proceedings, mainly because it is impossible for petition to be disposed within 60 days. Now, section 24 provides duty of tenant and landlord. So it says unless agreed otherwise, essential repairs in a year involving expenditure up to 5% of the annual rent be carried out by tenant at his own cost. So if any repairs in any essential repair which are merely 5% of the value of the rent payable in the year, in that case it is upon the tenant to incur all the cost and make the repair. But over and above such amount, it is the duty of the landlord to carry on such repairs on receiving notice from tenant. So in that case, he may refuse to do all the necessary repairs. So for that, it is provided that if landlord fails to undertake such repairs within 15 days of receipt of notice, the tenant may move to rent authority for permission to undertake repairs with the estimate. So he have to provide estimate to the rent authority, and in case the within 15 days landlord does not reply or does not make any such repairs, the tenant may move to the rent authority. So if rent authority grants permission to the tenant, it shall pass orders with respect to recovery of such costs from landlord by setting off from rent payable by the tenant. So it is very simple because he has to recover the costs which are above over and above 5%. So in that case, uh, rent authority would direct that the rent payable by tenant would be set off against the all the payment which the tenant has made in terms of essential repairs which are more than 5% of annual rent. It further provides procedure under section 23 shall apply to proceedings under this section as well. So this application also has to be disposed within 60 days. Section 24A provides disposal of pending proceedings under Section 23 or 24. All the pending application before rent tribunal shall be decided by it as if the act is not amended by 2017 Act. So it basically says that the proceedings which were pending on the date of enactment of the act shall be decided as if this act is not amended. Chapter 7 is the last chapter, which is miscellaneous. Section 25 provides for inspection of premises. So this is important section. Landlords rights to inspect. So three things are to be remembered from this section. That is, inspection has to be conducted at daytime first. Second, by giving prior intimation of at least 7 days. Third, it can be conducted only once in 3 months. So next, section 26, members and staff of the tribunal to be public servant and their control. So this is not very important. You may read from this sections. Section 26A provides similar provision for rent authority. Section 27 makes the provision of limitation act to applicable to the rent act. Section 28 provides for court fees. So this is also important provision. On Basically it provides for on petitions, application or appeals filed before tribunal, court fees payable be same as if suits, applications or appeal were filed before a civil court for the same relief. So for all the like for eviction matters, the court fees would be ad valorem. Ad Valorum. As per the value of the matter, it would depend upon the annual rent of the property, except as follows. So it specifically provides for court fees for certain purposes. That is, first is joint petition for limited period of tenancy under Section 8 and on appeal against such order. It is also ad valorem court fees as per Rajasthan Court Fees and Suit Valuation Act 1961 on annual rent of next year irrespective of period of tenancy. So if the tenancy is for year 2021, so court fees would be payable for the next year rent, because it would be increased by 5% annually, and on that amount court fees would be payable as per ad valorem rule. So, secondly, section 22E, that is revision of rent for improvement or diminution, court fees is fixed 100 rupees, and for permission to discontinue or restoration of amenities, court fees is 100 rupees. For the permission by tenant for any essential rupees, the court fees is fixed rupees 100. Revision of rent under section 6 or 7 or an appeal against such order, 250 rupees is fixed fees. So, apart from these specific things, court fees would be payable ad valorem as if the petition is before civil court. Next, section 29 is overriding effect of the act. It says that anything contrary provision of this act would be given effect. So this is special act and it is not in it would be given preference. Section 32 provides repeal and saving. So from this section also question have been asked in exam. So it provides that this act repeals what? Rajasthan Premises Control of Rent and Eviction Act 1950. So जो 1950 वाला act था, that has been repealed by this act. So savings. So these things are not affected by the act. What is not affected? Anything duly done or suffered under the enactment so repealed, or any right, title, privilege, obligation, or liability acquired or incurred under the enactment so repealed, or any fine or any penalty, punishment incurred or suffered under the provision of an act repealed. So these things are already done according as per law, existing law. So there is no reason to these things to be affected by the new act. It also provides that notwithstanding repeal, all the pending proceedings will be dealt under the old act as if it was not repealed. However, within 180 days of enactment, plaintiff will be entitled to withdraw with the liberty to file under this act. So, after 180 days of the enactment, the plaintiff would have liberty to withdraw the earlier petition and file new petition within 270 days. And for that purpose, it would be deemed that he has filed the new petition as if he on the date on which original petition was filed. So now हमारे provisions are complete. Now we'll do previous year question. So question one is, under Rajasthan Rent Control Act, which of the following landlord is entitled to recover immediate possession of residential premises? So option A is armed forces, member of the armed forces of the union. Option B is retired employee of central government. Option C is a retired employee of state-owned corporation. So all of the above is the correct option. Question 2. As per Section 3 of Rajasthan Rent Control Act, Chapter 2 and Chapter 30 does not apply to option A, premises let out after the commencement of the Act for a period of 2 years through a registered deed. So this is incorrect. Option B, the premises let out to multinational company having paid up share of less than 1 crore rupees. So this is also incorrect because it applies only when it has paid up share capital more than 1 crore. Option C, the premises let out for residential purpose, the monthly rent of whereof is rupees. This is also not applicable. Option D is the only correct option, which says that premises belong to the government company as defined under the Companies Act. Question number 3. The time limit for disposal of petition under Section 9 of Rajasthan Rent Control Act is so basically Section 9 provides for the remedy of eviction. But जो इसका procedure है that is provided under Section 15, which provides that the eviction petition has to be disposed of within 240 days. So option 1 is the correct option. Question number 4. In the event of death of the person referred in subclause 1 of 2(1) of the Rajasthan Rent Control Act, in case of premises let out for residential purpose, who of the following, ordinarily residing with the tenant as a member of his family up to his death, shall be included within the definition of tenant? So, as we have already seen that 5% are included in the definition of tenant after the death of the original tenant. The That would be, let's see the option. Option A, surviving spouse, son, daughter, brother. This is incorrect. Surviving spouse, son, daughter, brother, sister, this is also incorrect. Surviving spouse, son, daughter, mother, father, this is the correct option. Question 5. Premises under Rajasthan Rent Control Act 2001 does not include option A, outhouse appurtenant to building, so it is included. Option B, accommodation in a hostel, this is not included. Option C, option D, so B is the correct option. Accommodation in a hostel is. Question number 6. Chapter 2 and 3 of Rajasthan Rent Control Act 2001 applies to A. Any premises let out to a citizen of a foreign country. No, it does not apply to such citizens. B. Any premises belonging to a vested in a university established by law. It does not apply to this also. Any premises belonging to government company as defined under 617 not applies to this also. So option D would be the correct option. Question 7. Under the provision of Rajasthan Rent Control Act 2001, a landlord has right to inspect the premises let out by him. Which of the following statement with reference to the inspection is incorrect? We have to see which of them is incorrect. One is inspection can be done during at daytime. This is correct. A prior intimation of at least 3 days to tenant is necessary. As we have recently seen, the prior intimation of 7 days is necessary. So this is incorrect option. Question number 8. Which provision of Rajasthan Rent Control Act 2001 deals with the permission to enter into limited period tenancy and for the grant of certificate for recovery of possession? So that is section 8 provides for limited period tenancy. 6 and 7 are for the revision of rent, and 9 provides grounds of eviction. Question 9. What is the remedy available to an aggrieved party against the against a final order passed by Rent Tribunal constituted under Rajasthan Rent Control Act 2001? So basically, this option is not available. Option 2 is also not available. Appeal under 19 clause 6 is the correct option. Question number 10. The repealment of Rajasthan Premises Control of Rent and Eviction Act 1950 by Section 32(1) of Rajasthan Rent Control Act 2001 affected which of the following? So it says that anything done or suffered to be done under 1958, any right acquired under earlier act, any fine incurred under the provision of act. So it does not affect, as we have recently seen, it does not affect any of these things. So none of the above option is the correct option. Question 11. On application under Section 22E, the Rajasthan Rent Control Act 2001, the the court fees shall be payable. That is basically 22E provides for revision of rent in case of, I think, increase or diminution in the value of the premises. So for that purpose, court fees is rupees 100. Option 2 is. Question 12. Under the provision of Rajasthan Rent Control Act, which of the following is not a requisite regarding inspection of rented premise? So option 1 is prior intimation of at least 7 days. It is mandatory. Premises shall be inspected in daytime. This is also important. Necessary as per the section. C. Such inspection shall not be carried out more than once in 3 months. This is also requisite of the section. Point number 4. Such inspection shall be carried out only in the presence of tenant. So this is incorrect option as it is not provided under the section. Question number 13. Under Rajasthan Rent Control Act 2001, an application made under section 23 shall be disposed by rent authority within from the date of presentation of application. So section 23 provides for the withholding of the amenities, and as we have seen earlier in this video itself, that it is the shortest time to dispose any application, that is 60 days. Option 3 is the correct. So friends, now we have finished the Rent Control Act and done all the previous year questions. I hope you find this the all the three videos important for in your preparation. Best of luck for the exam. Thank you.